Yeah, let's go ahead and set forth our appearances on the record. We'll start first with the plaintiffs, then we'll move to the defense.
Teddy Parker for plaintiff, Your Honor. Robert Egbert for plaintiff, Your Honor.
Good afternoon, Brianna. What's the plaintiff?
Eric Pepperwood for plaintiffs.
Brad Johnson, Tyler Watson, Mike Tetracito, and Eric Freeman for after defendants, Your Honor.
All right. And I have a question. I've looked at both special verdict forms, and as it relates to past compensatory damages in the form offered by the plaintiff, is there no claim for medical expenses?
Those have already been resolved.
Okay.
The past ones have.
That's what I'm talking about.
Yeah, the
Past.
past ones have been resolved, Your Honor.
Right.
Yeah, mix it up. Oh, here we go. I got this one.
Anything else?
Your Honor, just for the record, we do want to note that with regards to the different verdict forms, one of the issues in this case is the conduct that could establish punitive damages. We have two subsets of plaintiffs here, one for conduct that occurred in 2018 and one for potentially conduct that occurred after those injuries in 2020. So to the extent that we're asking to itemize these out, I would just repeat, this is based on jury instruction, which we now have a number 23 that has been stipulated to, and it reflects the need to evaluate each plaintiff based on the date of their injury. So with that, we would just ask for the court's determination.
What am I determining?
Which verdict form to use?
Oh.
Yeah, Judge, I thought you've already decided that.
No, but I'm trying to figure out, I'm looking here. What does it have to do with date of injury? I apologize, I'm missing something.
Sure, Your Honor. We have several plaintiffs that were hospitalized in 2018. We have several plaintiffs that were hospitalized in 2020. One of the major issues that they raised during trial was this idea that Anthony Randolph, for example, told Blaine Jones that they should recall the product. That occurred in November of 2020, according to Mr. Randolph's testimony. So to the extent that the jury is going to be relying on conduct that is considered to be the basis for liability for punitive damages, there's a difference between whether or not that conduct occurred with regards to the plaintiffs that were injured in 2018 versus the conduct that occurred afterwards for the plaintiffs that were injured in 2020. So we believe the verdict form that allows for a jury to determine punitive damages based on the individual plaintiff, as opposed to grouping them all together, is appropriate under the circumstances.
Judge, I don't think that's appropriate at all because under that line of reasoning, if I was getting $1 billion punitive award, it would be $1 billion times 12 plaintiffs. You know, it's specific to the plaintiff, and it's not specific to the plaintiff. It's a generic punitive award.
It's to the conduct in general, all the way across.
Oh, I understand that, I do.
And the fact that some of the conduct occurred pre-2018 versus less, and then it's some up until then some of it occurred in 2020. It's all continuous conduct. It's the conduct of the defendant that matters for punitive damages. It's not the plaintiff.
And so I want to make sure, is that why we have a specific request for punitive damages as to each plaintiff?
Correct, Your Honor, and it also goes to the excessiveness analysis that this court was likely going to have to do if punitive damages award is entered against the defendants.
I mean, that's fascinating when you think about it. That could actually get out of control if they, each plaintiff, you realize that, right?
Depending on the argument, Your Honor.
No, I guess depending on ultimately what the findings are.
Yeah,
So, I mean, potentially they could.
For punitive damages for each plaintiff, Your Honor, that would potentially get out of control.
That's why you exist, Your Honor, to determine the excessiveness of the award.
Well, ultimately, whatever determination I make as far as excessiveness of the award would be tied to, under State Farm, to the compensatory damages, right?
Correct, Your Honor.
Yeah. All right. For the record, I don't mind saying it, I don't think it would be appropriate to give punitive damage determinations as to each individual plaintiff.
Your Honor, we just asked that our proposed verdict form be marked and launched for the record.
And that's fine.
Thank you, Your Honor.
I can see where that could be really excessive. All right. What else do we need to do?
I think we're ready to roll, Your Honor.
Well, Your Honor, there was some discussion during the break about whether the Zoom link would resume now that all the witnesses have been completed.
All right. And what was the discussion about?
Oh,
I mean,
I guess it was about everyone agreed.
Judge, we have no objection.
You didn't have to be there, Judge.
We have no
Pardon?
objection.
I mean, I don't know what do we have a stipulation, I guess? That
We have
Zoom
no
link-
objection, Your Honor.
I don't know anything about it either, Your Honor.
We're going with Mr. Freeman here, Your Honor. No objection?
Again, no objection. I didn't know what their position was. We didn't know what your position was. We just,
Well, when it comes to issues like that, I really don't have any issue as far as making it available. My only concern is this, and we had a business court matter about 2 weeks ago, and it was dealing specifically with a company that was being traded. I don't think it was NASDAQ. I think it was on a big board, and there was a potential merger. And so I wanted to make sure that the shareholders specifically had access to the discussions. And we had things in the interim, but the bottom line is this: at the time of the hearing, with the case being open to Zoom, we had someone unfortunately show videos that weren't appropriate to be shown in court. If everyone understands what I'm saying.
Oh, absolutely.
Yeah.
We were here.
Yeah,
Oh, were you here?
yeah.
Mr.
I
Cook
remember
and I
that.
were.
Yes. What do I do about that?
It was another case.
Your Honor, my only concern is if Zoom's going to somehow impact our ability to put our exhibits up and close, et cetera. And if there's any concern about that, I'd assume it's not happen.
It won't judge. And there's not gonna be nothing on the screen. Zoom is not gonna be on the screen.
Is there going to be any way anyone can show?
No, Judge, because Zoom is not gonna be on the TVs.
Okay.
I'm gonna log in, they're gonna be able to hear us and see us, but we won't see the Zoom screen because they're gonna have their presentations on the screen.
All right. Well, my next question is this: will the individuals watching on Zoom be muted?
I
'Cause
can
that-
mute everyone.
Because I just want to make sure that we don't have what happened
Yep,
before,
I agree.
Solid plan, Your Honor.
right? So if he can do that, we'll permit Zoom to have, but if he can make sure, because I don't want that to happen, especially with the jury in here and also the interest that individuals might have, that's my concern.
At what point do you want me to go into Zoom? Jury instructions or closing arguments? At what point?
Probably closings.
Either one's fine with us, Your Honor.
Sure.
Whatever.
Closing?
Closing's fine, yeah.
Right, because the jury instructions, they're not going to want to read it, listen to that.
Nobody wants to.
You can ask all questions you want to ask.
Counsel, can I have you email me your proposed verdict forms? Because I can't have judge's notes on them.
We're printing a clean copy right now.
Thank you.
Will you look at that one to see if I can get it?
And then same with the proposed, the defense's proposed verdict forms, and then the proposed jury instructions that were offered and not.
Yeah, we'll email those to you.
Thank
Yeah,
you.
I'll send those. This is one you email. Yeah, and Your Honor, this is correct. We have no objection.
Jury instructions?
Thank you, ma'am.
Thank you, Your Honor.
How many of them are there?
I think Robin can.
Well, it's less than 40, right? So that's a good thing. I
Read them
think.
twice, Your Honor.
Yeah. All right. So, I guess at this point, are we ready for the jury?
Yes, Your Honor.
Yes, Your Honor.
And I just want to make sure where for some reason, I'm having difficulty with this. We're actually going to read the jury instructions. And the reason why I say that, the case is actually going much quicker than I anticipated.
I have the verdict form.
And this is the one that's going to the jury.
And from a closing argument perspective, what do we anticipate accomplishing this afternoon?
Judge, I'm hoping to get all mine done and maybe we'll get Mr. Parker started.
Okay. So the defense doesn't have to worry about doing openings probably until tomorrow?
No, Your Honor.
Hope so.
Do we have any defense exhibits as that? Hold on for a second.
No.
What do you need?
I have nothing that's in there.
No, Your Honor.
So we won't have any admitted exhibits from defense?
We got those in through plaintiffs as we went through the case in chief, so we're good.
Okay.
Thank you.
Thank you, sir. I've got a difficult time getting my head around it. Pardon? Yeah. That's why I keep pausing. What are we doing? And I appreciate the font being a little larger.
All right, the jury.
Thank you. Find out.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
And ma'am, have we gone on the record as far as appearances are concerned? We have? Okay, just want to make sure. All right. Okay, ladies and gentlemen of the jury, both the plaintiff and the defense have finished their cases in chief. And so we're actually moving a lot quicker than I even anticipated. Because what I'm getting ready to do right now is read to you the jury instructions in this case. Do you understand that? And for the record, subject to any noted objections lodged with the court, do the parties, are the parties familiar with and approved court's proposed jury instructions 1 through 34?
Yes, Your Honor.
Yes, sir.
All right. And subject to any objections already lodged with the court, are the parties familiar with and approve the proposed verdict forms in this matter?
Yes, Your Honor. Yes, Your Honor.
Yes, sir.
Okay. Well, ladies and gentlemen of the jury, I'm about to instruct you on the law that applies to this case. And understand the law requires me to read in open court the jury instructions. But I want you to remember this, and this is very important to remember. We will make copies of the jury instructions, and you'll have them with you during deliberations. And so if you're concerned about taking notes and those types of things, you don't have to worry about that because you'll have an actual copy. Just as important too, we talked about jury instructions at the very outset, and I explained to you that this is essentially your roadmap or your rules of the road as far as how you deliberate in this case. You remember we talked about that. And so remember, look at the jury instructions in this regard. Number one, it's going to give you what the law is, and just as important to it, explain to you what your duty, role, and responsibilities will be as a jury in this case during deliberations. You understand that? These instructions are important in this regard in that every word has a significance, but you're not supposed to take any instruction and make a determination that it's more important than another instruction. You look at them as a whole, you understand that. And then ultimately you decide what the facts are in this case. All right. And so anyway, ladies and gentlemen of the jury, jury instruction number one. It is my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. Instruction number two. In these instructions and on the verdict form, defendants, AffinityLifestyles.com, Inc., a Nevada corporation, DBA Real Water, and Real Water, Inc., a Delaware corporation, shall be collectively referred to as Real Water. The jury instruction number three. If in these instructions any rule, direction, or idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you're not to single out any certain sentence or individual point or instruction and ignore the others, but you're to consider all of the instructions as a whole and regard each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. Jury instruction number four. One of the parties in this case is a corporation. A corporation is entitled to the same fair and unprejudiced treatment as individuals would be under like circumstances, and you should decide the case with the same impartiality you would use in deciding a case between individuals. Instruction number five. The masculine form is used in these instructions, if applicable, as shown by the text of the instruction, and the evidence applies to a female person or a corporation. Jury instruction number six. Although you are to consider only the evidence in this case and reach in a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you're not limited solely to what you see and hear as witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Instruction number seven. If during the trial I have said or done anything which has suggested to you that I'm inclined to favor the claims or positions of any party, you will not be influenced by any such suggestion. I have not expressed nor intended to express, nor have I intended to intimate, any opinions as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inferences should be drawn from the evidence. If any expression of mine has seemed to indicate an opinion relating to any of these matters, I instruct you to disregard it. Jury instruction number 8. The evidence which you are to consider in this case consists of the testimony of witnesses, the exhibits, and any facts admitted or agreed to by counsel. Statements, arguments, and opinions of counsel are not evidence in the case. However, if attorneys stipulate as to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuations suggested by a question asked a witness. A witness is not evidence, a question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside of the courtroom is not evidence and must also be disregarded. Jury instruction number 9. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigations of the facts or the law or consider or discuss facts as to which there is no evidence.
Consider or discuss, Your Honor.
Which one?
You let that discuss.
Okay.
Consider or discuss.
All right. You must not make any independent investigation of facts or the law or consider or discuss as to which there is no evidence. This means, for example, you must not on your own visit the scene, conduct experiments, or consult reference works for additional information. Jury instruction number 10. There are 2 kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is indirect evidence. That is, proof of a chain of facts from which you could find that another fact exists, even though it has not been proved directly. You are entitled to consider both kinds of evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give any evidence. It is for you to decide whether a fact has been proved by circumstantial evidence. Jury instruction number 11. In determining whether any proposition has been proved, you should consider all of the evidence bearing on the question without regard to which party produced it. Jury instruction number 12. If counsel for the parties have stipulated to any fact, you will regard that fact as being conclusively proved as to the party or parties making the stipulation. The following stipulations between Real Water and Lisa King have been agreed to. 1. The parties hereby agree that damages regarding future medical treatment as to plaintiff Lisa King shall be awarded in the sum of $12 million. 2. The parties hereby agree that plaintiff Lisa King has been diagnosed with and currently suffers from post-traumatic stress disorder, PTSD. Instruction number 13. Certain testimony has been read into evidence from a deposition and or shown by video. A deposition testimony is taken under oath before trial and preserved in writing. You are to consider that testimony as if it had been given in court. Jury instruction number 14. When a party to a lawsuit is a corporation, the other party may schedule a deposition under the Nevada Rules of Civil Procedure 30b-6, requiring the corporation to designate one or more officers, directors, managing agents, or representatives to testify on its behalf on matters known or reasonably available to the corporation. The person so designated shall testify as to matters known or reasonably available to the organization. The testimony of the Rule 30b-6 designee is binding on the corporation. Jury instruction number 15. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to observe the matter to which he or she testified, the reasonableness of his or her statements, and the strengths or weaknesses of his or her recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of this testimony which is not proved by other evidence. Jury instruction number 16. An attorney has a right to interview a witness for the purposes of learning what testimony the witness will give. The fact that a witness has talked to an attorney and told him what he would testify to does not, by itself, reflect adversely on the truth of the testimony of the witness. Jury instruction number 17. A person who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation may give his or her opinion as an expert as to any matter in which he or she is skilled. In determining the weight to be given to such opinion, you should consider the qualifications and credibility of the expert and the reasons given for his or her opinion. You are not bound by such an opinion. Give it the weight, if any, to which you deem it entitled. Instruction number 18. An expert witness has testified about their reliance upon books, treatises, articles, and/or statements that have not been admitted into evidence. Reference by the expert witness to this material is allowed so that the expert may tell you what they relied upon to form their opinions. You may not consider the material as evidence in the case. Rather, you may only consider the material to determine what weight, if any, you will give to the expert's opinion. Jury instruction number 19. A hypothetical question has been asked of an expert witness. In a hypothetical question, the expert witness is told to assume the truth of certain facts, and the expert witness is asked to give an opinion based upon those assumed facts. You must decide if all of the facts assumed in the hypothetical question have been established by the evidence. You can determine the effect of that assumption upon the value of the opinion. Jury instruction number 20. The lawyers and witnesses have shown you charts and summaries to help explain the facts. The charts or summaries themselves, however, are not evidence or proof of any facts. Charts and summaries are only as good as the underlying evidence that supports them. You should therefore give them only such weight as you think the underlying evidence deserves. Instruction number 21. Whenever in these instructions I state the burden of proof rests upon a certain party to prove certain allegations made by him, the meaning of such an instruction is this: that unless the truth of the allegation is proved by a preponderance of the evidence, you shall find the same to be not true. The term preponderance of the evidence means such evidence as, when weighed with that opposed to it, has more convincing force, and from which it appears that a greater probability of truth lies therein. Jury instruction number 22. Plaintiff asserts claims for strict liability for a defective product. The court has already determined as a matter of law that the real water product consumed by plaintiffs was defective and unreasonably dangerous, and that the defective real water was the cause of the injuries asserted by each plaintiff. Thus, The only issue remaining to be determined by you are, 1, the amount of compensation that should be awarded to each plaintiff, and 2, whether Real Water is liable for punitive damages. Jury instruction number 23. You must award damages for each plaintiff. In determining the amount of losses suffered by each plaintiff, you will take into consideration the nature, extent, and duration of the injuries or damages you believe from the evidence each plaintiff has sustained, and you will decide upon a sum of money sufficient to reasonably and fairly compensate each plaintiff for the following: the physical and mental pain, suffering, anguish, disability, disfigurement, permanent injury, and loss of enjoyment of life endured by each plaintiff from the date of his or her injury to the present. The physical and mental pain, suffering, anguish, disability, and loss of enjoyment of life which you believe each plaintiff is reasonably certain to experience in the future as a result of his or her injuries. The reasonable medical and psychological expenses which you believe that each plaintiff is reasonably certain to incur in the future as a result of his or her injuries. The court has already determined the past medical expenses for each plaintiff as a result of his or her injuries, as well as the future medical expenses for plaintiff Lisa King. Jury instruction number 24. No definite standard or method of calculation is prescribed by law by which to fix reasonable compensation for pain and suffering, nor is the opinion of any witness required as to the amount of such reasonable compensation. Furthermore, the argument of counsel as to the amount of damages is not evidence of reasonable compensation. In making an award for pain and suffering, you shall exercise your authority with calm and reasonable judgment, and the damages you fix shall be just and reasonable in light of the evidence. Jury instruction number 25. You should decide the case for or against each plaintiff separately, as if it was a separate lawsuit. Each plaintiff is entitled to separate consideration of their own claims and defenses. Unless I tell you otherwise, all instructions apply to each plaintiff. Jury instruction number 26. Plaintiffs Glenn Morris and James Delmar were previously diagnosed with PTSD before suffering their injuries from Real Water. A person who has a pre-existing psychological condition at the time of an injury is not entitled to recover damages, therefore. However, they're entitled to recover damages for any aggravation of such pre-existing psychological condition resulting from the injury. This is true even if the person's psychological condition made them more susceptible to the possibility of ill effects than a normally healthy person would have been, and even if a normally healthy person probably would not have suffered any substantial injury. Where a pre-existing psychological condition is so aggravated, the damages as to such condition are limited to the additional injury caused by the aggravation. Jury instruction number 27. Non-economic damages, such as damages for past or future pain and suffering, may not be awarded in this action for the injury or death of a pet. Jury instruction number 28. According to the U.S. Department of Health and Human Services standard mortality table, the life expectancy of a female Hispanic person age 52 is 34.3 years. This fact should be considered by you in arriving at the amount of damages to award plaintiff Lisa King. According to the U.S. Department of Health and Human Services standard mortality table, life expectancy of a female black person, age 47, is 34.1 years. This fact should be considered by you in arriving at the amount of damages to award plaintiff Andrea Bourdonnais. According to the U.S. Department of Health and Human Services standard mortality table, the life expectancy of a male Hispanic person age 20 is 59.8 years. This fact should be considered by you in arriving at the amount of damages to award plaintiff Abraham Alvera. Life expectancy shown by the mortality table is an estimate of the probability that should be probability, I think. Okay. Is an estimate of the probability, or probably.
Should be the estimate of the probability of the average.
That's what I'm thinking, yeah. Of the average remaining length of life of all persons in our country of a given age, and it is for you to determine the probable life expectancy of plaintiff from the evidence in this case, taking in consideration all of the evidence bearing on the same issue. Jury instruction number 29. Whether any of these elements of damages have been proven by the evidence is for you to determine. Neither sympathy nor speculation is a proper basis for determining damages. However, absolute certainty as to the damages is not required. It is only required that plaintiff prove each item of damage by a preponderance of the evidence. Jury instruction number 30. You may consider whether you should award punitive damages or exemplary damages against real water. Punitive or exemplary damages are to make an example of or punish wrongful conduct. You may, in your discretion, award such damages if, but only if, you find by clear and convincing evidence that the defendants were guilty of oppression, fraud, or malice, express or implied, in the conduct providing the basis for liability. Oppression means despicable conduct that subjects a person to cruel and unjust hardship with conscious disregard of the rights of the person. Fraud means an intentional misrepresentation, deception, or concealment of a material fact known to the person with the intent to deprive another of his or her rights or property, or to otherwise injure another person. Implied malice means despicable conduct engaged in with a conscious disregard for the rights or safety of others. Conscious disregard means the knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to act to avoid those consequences. At this time, you are to decide only whether real water engaged in wrongful conduct warranting an award of punitive damages, and if so, whether an award of punitive damages against real water is justified by the punishment and deterrent purposes of punitive damages under the circumstances of this case. If you decide an award of punitive damages is justified, you will later decide the amount of the punitive damages to be awarded after you've heard additional evidence and instruction. Jury instruction number 31. Clear and convincing evidence is that measure or degree of proof which will produce in your minds a firm belief or conviction as to the allegations sought to be established. It is an intermediate degree of proof, being more than a mere preponderance, but not to the extent of such certainty as required to prove an issue beyond a reasonable doubt. Proof by clear and convincing evidence is proof which persuades you that the truth of the contentions is highly likely. Jury instruction number 32. When you retire, to consider your verdict, you must select one of your number to act as foreperson, who will preside over your deliberations and will be your spokesperson here in court. If during your deliberations, you will have all of the exhibits which were admitted into evidence, these written instructions, and a special verdict form which has been prepared for your convenience. In civil actions, 3/4 of the total number of jurors may find and return a verdict. This is a civil action. As soon as 6 or more of you have agreed upon each answer required by the directions in the special verdict form, you must have the verdict signed and dated by your foreperson, and then return with it to this room. Jury instruction number 33. If during your deliberations you should desire to be further informed on any point of law, or hear again portions of the testimony, you must reduce your request to writing, signed by the foreman. The officer will then return you to court where the information sought will be given to you in the presence of the parties or their attorneys. Readbacks of testimony are time-consuming and not encouraged unless you deem it a necessity. Should you require readback, you must carefully describe the testimony to be read back so that the court reporter can arrange her notes. Remember, the court is not at liberty to supplement the evidence. Instruction number 34. You will now listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberations by the evidence, as you understand it and remember it to be, and by the law as given in these instructions, and return a verdict which according to your reason and candid judgment is just and proper. All right, let the record reflect that jury instructions 1 through 34 have been read to the jury. Is that correct, counsel?
Yes, Your Honor.
Yes, Your Honor.
All right. So, at this time, are we ready to begin with closing argument?
Yes, Your Honor.
All right. Mr. Kemp, you have the floor, sir.
Good afternoon, everybody. Let me start by thanking you for your service on this jury. Judge Williams has thanked you a number of times. The plaintiffs thank you. I thank you. I think as you've come to find out, this is what our whole system of justice relies upon, you, the jury. And again, thank you very much. Now, as the judge said and is set forth in jury instruction 22, there's 2 issues in this case. First issue, compensatory damages for the plaintiffs. And then the second issue is the yes or no on the punitive damages. So let's start with the verdict form. Shane, can I have that? This is what the verdict form is going to look like. Can you blow up maybe the second page a little bit, Shane? Okay, so you're going to be asked to fill in a number for compensatory damages for each one of the plaintiffs. First of all, for their past physical, mental pain, suffering, anguish, disability. And then, next one over, Shane. Then for the, go ahead, down. Then for the future, okay? So there's one number for each one of the plaintiffs, all right? And I'm gonna go down and the jury instructions talk about what's included in past and future damages, but I'm gonna talk about that. Okay, and before discussing the permanent injury that each one of the plaintiffs in this case suffered, let's start out with the toxin, okay? Shane, toxin was hydrazine. We know now that real water, each and every bottle, contained hydrazine. It's a toxic rocket fuel. No dispute about that. It causes acute liver failure. No dispute about that. You heard their expert this morning admit to that. And hydrazine is what caused the liver injuries in the case. You heard their expert say that this morning. So just to review, next, Shane. These are the FDA concentrate tests one more time. They're in your jury notebook. FDA came in and tested 3 different samples of concentrate. Each one was determined to have a very high level of hydrazine in it. And again, hydrazine is the same rocket fuel that was used to launch the moon rocket in 1969. It's the same thing that's used, or derivatives used for the space, for Elon Musk's SpaceX rockets at present time. This is a rocket fuel that is a toxin. Okay, third point, it is highly toxic. We call Dr. Kosnet as the very first witness in this case. Remember, we played his video. They didn't call a toxicologist. Real Water could have, they didn't. So this is what Dr. Kosnet told you about how dangerous hydrazine is. This is the machinist who died after just 1 day a week exposure. Go ahead.
This is one of the studies that he saw, and this was published in Finland, and actually it was a gentleman who worked with hydrazine 1 day a week. He handled it. They didn't specify exactly, but he probably had some inhalation exposure and thermal exposure, and he was a machinist. And after 6 months, he started to get ill, and he wound up actually dying. And they attributed his death to being exposed to hydrazine. And when they did an autopsy, they found evidence of liver damage.
And Dr. Kosnet also told you about a second case. This was another man who was trying to cure himself of cancer. He was taking hydrazine to cure his cancer. Instead, he got encephalopathy, the brain swelling. Again, Dr. Kosnet.
It was admitted to the hospital. He had severe liver damage. His bilirubin was 43.2. The normal was less than 1.2. And despite aggressive treatment, he went out to die. Okay, both hepatic and GIP. And we sorry, just cut you off, Dr. That's hepatic encephalopathy. Yes, he died of hepatic encephalopathy, which is a form of brain swelling and brain damage that you get in the Remember, that was talked about in some patients. In this case, had hepatic encephalopathy. So this is a guy who's taking this hydrazine, and he died, and he had hepatic encephalopathy.
So hydrazine is so toxic that even when you inhale it for a brief period of time, when you drink a small amount of it, people die. And there's one person that died in this case. Not in this specific case, but in this outbreak. One person died. They talked about it a little bit this morning. And it has to be emphasized that there wasn't just a little bit of hydrazine in the real water. There was an incredible amount of hydrazine. We called Dr. Najim, and this is what he told you. So there was 1 billion times more hydrazine in real water than the EPA standard. Not 1 million, not 10 million, but 1 billion times more hydrazine in this real water. So the real water with the rocket fuel was poured on the livers of each and every one of the 13 plaintiffs in this case. It's rocket fuel, highly toxic. And in this case, these plaintiffs, they didn't have the exposure for a brief period of time. They drink it for days, weeks, months, years. And again, we talked about that airman. 1 minute exposure to hydrazine of that F-16 airman, he died. Okay, so these people all have an extensive exposure. Fourth point. The hydrazine caused the liver damages of the plaintiffs in this case. That's been agreed to. The judge just read you the jury instruction. That's an agreed to, stipulated fact. So causation is not in dispute. And I bring that point up because some of the jury questions seem to be indicating that there was still some issue with causation. That is not in dispute in this case. The rocket fuel in the real water is what caused these injuries. So it's not your job to determine causation, it's your job to determine compensation for those particular injuries. Okay, so the first issue in this case is what are appropriate compensatory damages for an acute liver failure. And acute liver failure involves the liver, and I've showed, this slide's probably been showed 10 times in the case. I'm not going to go through it. But the liver is a critical organ. Without a liver, you just can't live. That's why liver transplantation is the only option. So let's go to acute liver failure, Shane. So acute liver failure is a critical medical condition. Near complete loss of liver function happens weeks, days. Usually people have no pre-existing liver injury, and that's the case of all 13 people in this case, no pre-existing liver injury. Usually there is required ICU, and you've seen virtually every plaintiff in the case went to the ICU. And acute liver failure means it stops working. It just doesn't work. Next, Shane. No, next, the results. So here we have the AST, ALT, and ammonia level for each one of the plaintiffs. Now, I want to explain this ALT, AST a little deeper because I think there's been some misconception on the part of the defense. When you have acute liver failure, when a toxin is attacking your liver and the liver is not working, the ALT and the AST go up, okay? That is an indication that something is attacking your liver. When that attack stops, when whatever's attacking your liver stops, the ALT and AST go down. But that does not mean that there is not permanent damage, because ALT and AST, they just measure whether the liver is working at the time. They don't measure permanent damage. And I'm going to show you some of the testimony on that. And so that's why I think it was kind of misleading. The defense got up here and said, oh, these people don't have permanent damage because their ALT went down. Well, all that means is that they were not drinking the rocket fuel at that time. It doesn't mean that they didn't have permanent injury. So that's a critical point. But anyway, we can see that something is attacking the livers of all these people because we have extremely high ALT levels and we have extremely high ammonia levels for everyone. So the highest one here is Mr. Morris. I remember him. He was the veteran that served, I think, 2 tours in Iraq. He wins the prize, if there's a prize to be won, 8,310 AST level. Normal's 27. He's over 300 times a normal AST level. And so they're unbelievably high levels, and they show you what critical condition that these people were in when they went to the hospital. And Dr. Hudson explained that all of these people, except Strong, who had serious liver injury but not acute liver failure, and Mrs. Garcias, who had, I would call it a moderate liver damage, and I'm going to get into it. But Dr. Hudson explained that all 11 of the other ones had acute liver failure. Shane, can I have his clip, please?
When you consider the medical records as a whole of these plaintiffs, Dr. Hudson, is it clear to you that hydrazine has caused their acute liver failures?
Yes, sir. It is clear.
Is it also clear to you that the consumption of hydrazine-laced real water has damaged their livers?
Yes, sir.
Okay, and that's not really in dispute. You heard Dr. Alsina, he's the defense hepatologist, testify this. He agreed with Dr. Hudson on this point. Causation is not an issue in this case. Drinking rocket fuel causes permanent liver injury. I'll say it again. Drinking rocket fuel causes permanent liver injury. Here's Dr. Hudson again.
Dr. Hudson, is it fair to say that because hydrazine is such a unfamiliar toxin in terms of the human consumption, that hydrazine, just by its nature, its toxicity, causes permanent liver injury?
Yes, sir. I believe that hydrazine, because of its toxicity and the minimal amount of exposure that you really have to have in high concentrates, that causes permanent damage.
And again, there's not minimal exposure in this case. Everyone drank it for weeks, months, years, and there's not a small amount in this case. Again, Dr. Najim said there was 1 billion times more than the EPA standard. That's why it causes permanent damage. And you heard Dr. Alsina this morning. He said he can't rule that out. Their expert said that he cannot rule out permanent damage. Now, back to the verdict form. So there's 2 places where you need to decide the damages number for each plaintiff. Shane? Oh, okay. Let's start with the jury instruction first. Okay. Jury instruction number 23. Okay. Physical and mental pain, suffering, anguish, disability, disfigurement, permanent injury, loss of enjoyment in life endured by the plaintiff from the date of his or her injuries to the present. Okay, these are past damages. So Mrs. Bourdonnais, for example, Lisa King, they had their consumption in March of 2018. So you would figure their damages from that date into the present date. That's past damages. The other plaintiffs who are 2020 cases, you figure it from 2020 to the present date. Those are all past damages. And take a look at these subparts. Basically, there's 4 different subparts here. Go ahead, Shane. Okay, I think Shane's a little, so that should be jury instruction 23. No, Shane, you don't have to. Okay, thank you. Okay, 4 different subparts. The physical pain, suffering, and anguish. 2, the mental pain, suffering, and anguish. 3, permanent injury. And 4, loss of enjoyment of life. So let's talk first about what physical pain, suffering, and anguish is. And let me give you an example of someone's physical pain from a video that we showed you. This is Nicole Chang. Go ahead.
Nicole.
Stop.
Let's go. Come on, you gotta go to the hospital.
Stop.
All the plaintiffs are like this. Days or weeks, debilitated by something, they don't know what, but all the plaintiffs testified that they were like this, with the exception of Gossius, and I'll get back to that. So, in addition to the physical pain they had mental pain, because they are going to doctors, hospitals, emergency rooms over and over again for weeks and months, and no one can give them an answer. No one can say this is the cause of your injury. And that causes a lot of anxiety and mental pain. Let me play a clip from Nigel, who talks about this.
And so you've seen, I think, 5 different medical providers. Can you describe what that was like?
At this point, I was giving up because they were like, oh, he's just having a mental breakdown. They prescribed me anxiety or depression medication, and that didn't help. I started having hallucinations, bad dreams. So I stopped taking the medication, but the dreams never stopped. They were getting progressive and worse.
Okay. And this is a nightmare that continues over and over again, because a lot of times here, the plaintiff goes to the hospital, gets some treatment, checked in, they don't know what's wrong, they're checked out, they go back to their house, they drink more real water, they get sick again, they're back to the hospital. Shane, can I have my next one, please?
So I told my husband that we've been going back and forth on how, like, you're sick, I know, we don't know what it is. And I just told him that day I knew I either went to the hospital or I was gonna die.
So we just don't have a poisoning situation. We have repeated poisoning, temporary periods where they're getting better because they stop drinking real water, and then they drink it again and right back in the hospital. Can I have my next slide, Shane? So they drink the poison, they drink the real water, they get sick, and here's the symptoms. You've heard everyone talk about them. They're nausea, they vomit, they fall down, they're confused, like Nicole was in that video. They get dehydrated because they're vomiting. So what do? They drink more real water, drink more of the poison. You know, the devil could not have devised a greater torture, because the poison that you are drinking is causing you to get dehydrated, so you drink more poison. They go to the hospital, they're poked and prodded, they're checked in. Most of them are there during COVID. They're alone, they're confused, they're afraid, they can't understand what the doctors are saying because they have mental confusion. And then the doctors didn't have any answers anyway. And many of them are told, back there, Shane, many of them are told that they either have to have liver transplants or they're gonna die. And they're gonna die, and they're there alone and confused, confronting this type of news. Slowly they get better. They drink the hospital water instead of the poison. The liver function tests improve because, again, like I said, that's an enzyme that when the toxin's removed, it goes down. Transplants are canceled. They're sent home without answers. They drink the real water again. Right back in the hospital. Drink the poison again. So it's kind of a vicious merry-go-round. And like I said, the devil himself could not have devised a greater torture system. It's a hidden poison. The poison is in an essential thing that you have to have, water, an innocuous substance. That's where the poison is. Next, Shane. And the doctors can't find it, because who would suspect that a bottle of water has rocket fuel in it? We're not blaming any of the doctors. I mean, the doctors didn't know that they were making this bottled water with this supercharging process. Only real water knew about that. Next, Shane. So like I said, this poison makes them vomit, get dehydrated. You drink more poison. You drink more poison. Next, Shane. And the confusion, no one can understand what's going on. The doctors don't know, it's hard. And then you get sick again. Next one, Shane. So, next, Shane. So there's 4 damages part to be compensated for under instruction 21. Physical pain, suffering, and anguish, mental pain, permanent injury, loss of enjoyment of life, and the mental pain. So let's talk about mental pain for a minute. This is what mental pain is. Next one, Shane. So they're alone in the hospital. It's in the middle of COVID. Your family's not there to help you communicate with these doctors. Next. Confused and delirious because the ammonia buildups, flooding their brains. You're not yourself. Next. Your body's failing every day because the liver's not working. Next. And most of them are told, and I'm going to get into the specifics in a minute, they have to take an emergency flight to California to replace the liver that God gave them with the liver from a stranger. They're told that in the hospital alone. And then when they drink the hospital water, they're not drinking real water, they slowly start to improve with regards to their liver functions, and they're still sick, they're still weak, they go home. No answers. Worst part about it, you don't know what has caused your injury, so you can't stop being injured in the future. So, I think this is horrible what happened to these people.
Your Honor, just as a pause.
Please, I'll rephrase it. Let's not go into what I think or Mr. Johnson thinks. Let's go to what his client said about this experience. Next, Shane.
Okay, and the next sentence it says the debilitation of liver failure, I have been to hell and back. Did I read that?
Yeah, it was a very
care what thing.
This is the man who made the concentrate. He's the executive vice president of Real Water. He got the same liver injury that these people did. He had acute liver failure. Remember, he went to Utah, drank it, and his father had to drive him home. And he told you what he thought the experience was like. Hell and back. Hell and back. That's Mr. Johnson's client. That's not me. That's not Mr. Johnson. That is binding testimony in this case as to what the experience was like. Hell and back. And it was hell and back. We had 2 combat veterans in this case. Okay? Shane? We've got Mr. Morris, again, the Iraqi war veteran, and we got Mr. Delmar, the Vietnam veteran. This is what Mr. Delmar told you about this experience.
I woke up that morning and I couldn't get out of bed. Couldn't walk. I couldn't ambulate. I was dizzy. I was disoriented. My vision was impaired. I crawled across the bedroom floor into the bathroom and hoisted myself up so I could relieve myself at the toilet. I hugged the wall, making my way back into the living room. I absolutely had no idea what happened.
This man served 2 tours of duty in Vietnam. Okay? Let me show you another example of mental pain and suffering from Vanya Diaz. Shane?
That I was scared. I was thinking that I'm going to die. Basically, that's what was happening, and we didn't know what was causing my condition, and I was getting worse in the hospital, so something was there that was making me close to dying, but it was good.
Let me give you one more from Nigel.
I would go to sleep, have these dreams of people's faces melting, and then wake up, especially in the hospital. I didn't know where I was. I wake up screaming. They'll try to calm me down. I called my partner, Jerome, and said, oh, they took my phone, and I'm on the phone, not knowing that I'm on my phone.
He's talking on the phone and he thinks his phone's missing. I mean, this is mental confusion. So these people need help. This is what Dr. Sands told you. This is the summary chart he gave you. PTSD, impairment of executive function, impairment of fine motor, personality problems. I don't want to go through them all. But I would note that Real Water has not pushed back on this. They didn't fight this. In fact, you heard Dr. Alsina this morning admitting that plaintiffs that go through acute liver failure have psychological problems and need counseling. He admitted it. He's their doctor. They didn't hire a psychologist to refute anything Dr. Sands said. And the reason is they know, like Blaine Jones said, that this was hell and back. PTSD. This was a life-changing nightmare with lifelong consequences. And that's the third. And let's go to the third damages element. Or maybe it's the fourth. Loss of enjoyment of life. Okay, what does that mean? I think the 2 best examples that we have in this case are the musicians. We had 2 musicians. We had JJ, recorded 3 rock albums after he left Vietnam, before he drank Real Water. And then we have Ginger. We played the video of her singing opera in the opening. Now she has problems. Shane?
I love to sing, and so when I moved here, I helped found Vegas City Opera, and I have tried every tool available to me to get back to what I love to do, right? We all have something we love to do. And I call it the stickiness. I can learn music, I can sing music, I think I'm still pretty good, but I can't get the memorization core, I can't get it locked in. And that means that I can't actually perform like a role on stage. So I can't actually sing in a role without a piece of music in front of me.
So we have musicians that can no longer make music. They can no longer do something they've done all their life that they had a gift for, and now that gift is taken away. But that's an example of loss of enjoyment of life. Virtually every plaintiff that testified that they have some sort of brain fog, that it's causing problems in their present day lives. Let me show you an example from Nicole Chang.
I mean, I still feel a bit of that brain fog, mental exhaustion, anxiety. That's a recent one for me in the last couple of years. I feel anxious.
And other plaintiffs have similar problems. Let me show you what Vanya Diaz said.
To know that I drink rocket fuel gives me tons of anxiety because I have no idea what long-term consequences that would have on my lifespan.
Okay, and most of the plaintiffs told you how they become more reclusive. They stay at home. They don't go out anymore. This is what Nigel said.
I want to get back to the old me, because I just stay in the house for the most part. But I don't go anywhere. I don't like to be social. I don't like to be around a lot of people. I just want to get back to me, and I don't really feel like myself anymore.
And one of the plaintiffs in this case was a child, 15 years old, when his liver failed. That's Abraham. The judge read you the jury instruction about his life expectancy. For the next 60 years, from today forward, for the next 60 years, he's going to have to live with what his client conceded was a hell and back experience with a permanent injury for 60 years. So let's talk a little bit more about the permanent injury. This is the only damages component that Real Water has contested in any way. This is the only one they've contested in any way. And this morning, I think Dr. Alsina even gave this one up. But in any event, they are trying to say these people are fine, and I'll get to that in a minute. Let's start with Dr. Hudson, first of all. He testified specifically, and these are all the plaintiffs except for Borden King. He testified specifically, and again, Gassius isn't included in this either, that they all have permanent liver injury as a result of drinking Real Water. Go ahead, Shane.
So to sum up, Doctor, in terms of all the patients, including Ms. Borden and Ms. King, have they all suffered permanent liver injury as a result of consuming Real Water?
They have.
And you give that opinion to a reasonable degree of medical probability and or certainty?
I do.
And what permanent injury do they have? They all have fatty liver. Okay, Shane?
9 of the 11 people here, through your review of the medical records, have now suffered fatty livers because of their consumption of Real Water.
Yes.
Fatty liver. That's something you get if you're either obese or you have diabetes. Neither one of the conditions any of the plaintiffs have. But they now, for the rest of their lives, have fatty liver. And did you hear one single expert from Real Water refute this? There wasn't a one. They tried to do mealy-mouthed denials of permanent injury, like saying, oh, they won't have acute liver failure again. They're not going into the hospital again. But they didn't say a word about the fatty liver. Didn't say one single word about it. They didn't contest the fact that there's fatty liver in these plaintiffs. Now, you've got to compensate the plaintiffs for past and future injuries, and that may seem like a hard thing to do, but in this case, we have a baseline. We have evidence that has been given to you in this case as to what an appropriate number would be. And remember, all the plaintiffs suffered the same symptoms, okay? Shane, can I have my next one, please? And we've gone through this, but these are all the common acute liver failure symptoms. The nausea and vomiting, the extreme fatigue. You saw Nicole, you saw the video. The encephalopathy, the inability to function, stumbling, falling down, JJ hugging his bathroom toilet, the high liver function tests, the hospital visits, the permanent liver scarring, they all have the same thing. Okay, so what we would suggest is that you formulate a common baseline for these type of damages. And what is a common baseline for an acute liver failure injury? There's testimony in this case about that. Shane? This is Blaine Jones. Again, he was the owner, the son of the owner of Real Water, charge of overall production. He made the concentrate. He got acute liver failure on October 5th, 2020. So we ask Blaine Jones, well, first of all, let me make sure that there's no dispute that he did have acute liver failure. Same thing as everyone else. He's diagnosed as critical, rushed into ICU. Next, Shane. Was this just text? Okay. Okay, let's see the video as to what Blaine Jones, the Vice President of Real Water, this is what he said with regards to appropriate compensation. Okay, it says, on the next sentence it says, the debilitation of liver failure, I have been to hell and back. Did I read that right?
Yeah, it was a very terrible thing.
This is the next sentence it says, the debilitation of liver failure, I have been to hell and back. Did I read that right?
Yeah, it was a very terrible thing.
Okay. If you want to go through this again, if I gave you $10 million, would you?
Yeah.
This is the testimony from the Vice President of Real Water evaluating an acute liver failure injury at $10 million. This is testimony. This is the only testimony in the entire case. Everything else is argument of counsel. If Mr. Johnson suggests a different figure to you, that is argument. That is not evidence. This is evidence. And again, it's from the Vice President of Real Water who went through a similar experience as did the plaintiffs in this case. Not as severe as most of the plaintiffs, but a similar experience. So what we're going to suggest is that this is where you start. This is the baseline, okay? And I'd also point out, Shane, can we have that back up? After this deposition was taken, he had the right to change this if he wanted. He could write a correction and change the 10 million to 8 million or any other number he wanted. And Real Water, they had the right to call other witnesses. Remember they called Brent Jones? Brent Jones's deposition was taken 4 months later. There was no correction from anyone at any time to this $10 million figure. And why is that? Why did they not correct that? Because they know that this is a fair compensation for an acute liver injury. And that's why we submit that this should be the standard that you use. So let's use that standard that Blaine Jones has given us for this hell and back experience. That standard of $10 million, let's use that standard and let's compare his injuries to the injuries of the various plaintiffs. So first of all, we have Nicole Cheng. That's Nicole's picture. And I've showed you the video. I'm not going to show it to you again. So she went to St. Rose November 11th, 2020. This is a slide from, I'm trying not to show it to you again. This is a slide from the hospital records. Same symptoms, nausea, vomiting, incoherent. She has the high AST, ALTs. Next, Shane. 336, 282, 2,843. We have the normals up there on the right, on the top right there, you see, so you can compare them. So they diagnosed her with acute liver failure and hepatic encephalopathy. Okay, I've explained that encephalopathy before. Next, Shane. This is another assessment. Again, no question about this, that she had acute liver failure. I think Dr. Alcina agreed with this today, and encephalopathy. And so you get encephalopathy when the liver is not processing ammonia anymore. So this is a picture of some ammonia. So the normal ammonia levels, something like 18 to 72. That's a waste byproduct the body produces. And when it builds up, it has to go somewhere, goes into the brain, and that's what causes the encephalopathy, brain confusion. Next, Shane. So she's got 135 level. Normal level's 18 to 72, so she's very, very high. Next, Shane. This is a demonstrative. This is intended to show you what happens when you have encephalopathy, okay? You get the ammonia, the fluid buildup in the brain. You see how you got the fluid on that's interfering with the electronic function of the brain? That's what happens when you have encephalopathy like Nicole had. Okay, she is in St. Rose for 7 days from November 11th, 2020 to November 18th, 2020. In addition to the ammonia, she had high lactic acid. Remember Dr. Alcina talked a little bit about that this morning. She measured 12. Okay, both of the findings of encephalopathy, the high lactic, proves that she had permanent liver injury. Again, here's Dr. Hudson. 12 is referring to her lactic acid.
12 means you've got a ton of cellular damage, like widespread cellular damage, and that's because the liver was so damaged it was not able to clear the lactic acid that is produced normally by our cells, because the liver clears the lactic acid. That's our main way of getting rid of lactic acid.
And is that an indication to you, in addition to everything else that you discussed, proof positive of liver damage caused by hydrazine?
Yes, sir.
Okay, and she had fatty liver, no question about it. This is the hospital record from the time she was hospitalized. Severe fatty infiltration of liver. No doctor from Real Water has testified this is gone. No doctor from Real Water has testified this is going away. As Dr. Hudson said, this is a permanent condition, a permanent injury that Nicole has. She's 37 years old now, and she has a permanent liver injury. So let's compare Nicole's case with Blaine Jones. And again, here's the standard. This is his $10 million figure. And this is evidence. Remember, this is evidence. Mr. Johnson jumped up and objected when I said something about my opinion, but this is evidence. So we'll see if he's got any evidence to refute this $10 million figure. Any evidence whatsoever. So let's compare Nicole and Blaine. So Nicole had 3,218 on her AST, ALT, 1434. We know Blaine's were high, but we don't know exactly what they were. Nicole had encephalopathy. We don't know if Blaine did. Remember, he testified he was out of it, but we don't have any encephalopathy diagnosis. Nicole has the permanent severe fatty infiltration of the liver. That's directly from the hospital records. Blaine's unknown. They're both in the hospital 7 or more days with acute liver failure. I would suggest that compared to Blaine's $10 million figure, Nicole should be slightly higher. Slightly higher. Okay? Now let's go to Nigel. Nigel went to the doctor's office, ER, or the hospital 9 times. 9 times over 2.5 months. This is the chart we showed you of all his medical visits. He suffered for over 3 months. Next one, Shane. This is one of his hospital records dated, I think, 12/2. It reflects that for the last 3 months, he's been suffered with these symptoms, and it got worse the whole time. Because every time he went to the hospital, they couldn't tell him what was wrong. He's dehydrated. He goes home. He drinks more real water, more rocket fuel on his liver. He gets sicker. Okay? So they diagnosed Nigel with acute liver failure and hepatic encephalopathy. Again, elevated ammonia. Next, Shane.
I was nervous because at that time I didn't know. Like a kidney, I know you can survive on dialysis, but a liver, I didn't know if it was the same. So I wasn't able to process anything, but I'm still nervous at the same time because I'm not feeling any better.
And this is when they told him that he had to go to a liver transplant center. They told Nigel, if you don't get better, you're going to a liver transplant center. Next, Shane. This is this is from the hospital record. If the liver functions do not improve in the next 24 to 36 hours, this patient is going to the liver center, transfer to a higher center. I think that means a liver center. Again, they're in LA. Most of these people are going to. So he's got to go for a transplant. Next, Shane. And this is his reaction when they told him that.
I was relieved that they actually found out what was going on in my body, but also scared at the same time because I really didn't know what that meant. I didn't know, does that mean I'm going to die? What is the result of having acute liver failure?
Okay. Again, mental anxiety. He thinks he's going to die. So let's go to the standard for Blaine again. This is Dr. Hudson saying he's got permanent injury, the fatty liver. Next.
Did he suffer, in your opinion, a permanent injury based upon his consumption of real water?
Yes, sir.
And again, no dispute from the defense experts on this. They tried to kind of attack this by saying, oh, he's not going to have acute liver failure. No defense expert told you that he doesn't have permanent injury, because he does. So let's compare him with Blaine. Again, here's Blaine's back shape. Here's Blaine's standard. Okay, Nigel. 9 ER hospital and doctor's visits over 2.5 months. Blaine had 3. Remember, he went to the hospital in Utah twice, then he went to the one here. So Nigel, more medical institutions, longer period of time. AST, ALT elevated, INR elevated. Both had acute liver failure. Nigel has fatty liver disease, permanent liver injury. We don't know if Blaine does. They're both counseled for liver transplant. And I would say that for using Blaine's standard, Nigel should be slightly higher just because he has permanent liver injury. So next, this is J.J. Delmar. Again, he's the Vietnam vet. He went to the ER at the VA with dizziness and fatigue. Then they flipped him over to UMC. He's got these measurements, AST, ALT, diagnosed with acute liver failure. He had an interesting story to tell you. I use the term interesting. I don't know if that's the right term. They put him on the death ward at the VA. They thought he was going to die, so they put him, he told you, on the high floor, the death ward. Here's his testimony.
It's at that time when she returned me to my bed that she said, "You got to get out of here." She said, "You know where you're at?" I said, "Well, in emergency." She said, "You're in a terminally ill ward. Nothing good happens up here."
The terminally ill ward. That's the death ward. That's where they put people that they think are dying. And that's where they put JJ. He's got permanent liver injury. I'm going to show you Dr. Hudson's testimony in a minute. But it hurts him every day. It hurts him nearly every day, and this is what he told you.
My liver has intermittent mild pain, sometimes no pain, sometimes on a scale of 1 to 10, a 5 or 6. There are certain foods that help with the pain. I'm surviving, I'm living. I'm not feeling sorry for myself. Life delivers you certain good times and bad times. I've always been a survivor.
Mr. Delmar, JJ, is in his 70s now. He explained to you that there's no bounce back for him. Okay? Next, Shane.
Given the different in times, Vietnam, as horrific as it was, I was young and hardy and resilient, and I was able to come back. 10 years that I made it. I'm not so young and hardy and resilient any longer. I'm 76 years old, and I've got to deal with this for the rest of my life.
The pain in your liver, correct?
The entirety of what I've gone through and what I go through day in and day out, yes, sir.
And there's no dispute that he has fatty liver, because here they did a CAT scan. Here's what the CAT scan found. Extensive fatty infiltration of the liver. Fatty liver. That's a permanent injury. Can I have the next one, Shane?
Mr. Delmar, from your review of his medical records, did he too suffer fatty liver as a result of his consumption of real water?
He did.
And is it your opinion that based upon that he suffered a permanent liver injury?
So there's uncontroverted proof that he has fatty liver. There's uncontroverted proof that this is a permanent injury. In real water, they want you to just speculate without any expert witness saying it, that this fatty liver just went away because the liver's magic. You know, magic liver heals itself. But no expert testified to that because it's not true. He's got a permanent liver injury, fatty liver. So let's compare him with Blaine's situation. Again, here's what Blaine said. So JJ got put into the death ward. Blaine didn't. Blaine was in ICU. They both had acute liver failure. Blaine was told that he might need a liver transplant. JJ was told he might die. Blaine was probably hospitalized a couple days longer. JJ has permanent injury, causes him pain almost every day. Blaine's recovered. Okay, we would suggest that the baseline that JJ should be slightly higher because he has permanent injury. Let's go to Vanya Diaz. Vanya was one of the most injured of the 11 plaintiffs I'm going to be discussing. She went to the ER at Henderson, November 12th. Same symptoms as everybody else: nausea, vomiting, dehydration, chills, no balance. She's in Henderson for 5 days. Same symptoms: shortness of breath, memory loss, back pain, weakness. They were really concerned about her, so they were taking her AST and ALTs twice a day. So we got 2,000, 2,600, 3,400, 3,200. She got worse as she was in there. 274, 636. Then they almost double on the next day. So because she was getting worse, they told her, first of all, if things get worse, we got to send you to the liver center in Los Angeles to get the liver transplant. And I've talked a little bit about transplant operations, or it's been talked about in this case. And I don't know if I need to go through this again. It's not a great procedure. Not a great procedure. The doctors at Henderson, they thought, like JJ, they thought Vanya was going to die. Here's what they said. This is the medical records. Due to the imminent risk of death, they had their counseling person talk to her for 60 minutes about the potential that she was going to die. So what did they do next? They did a liver biopsy. They took the needle, stuck it into her liver, ripped out a sample, and looked at it on her slide. Next, Shane. So they find that it's recent. Okay, it's recent. It was a recent toxin. Okay, that's not really in dispute. But this is important. They found regenerative nodules. They did a liver biopsy, pulled out the tissue sample, and they found regenerative nodules. So here's the key slide. Blue is bad. Blue means scarring. It's right there when they did the trichrome slide on her. The path report, this is the independent pathologist, okay? The independent pathologist back in 2020 finds regenerative nodules. This isn't one of the experts for plaintiffs or one of the experts for defendants. The independent pathologist finds regenerative nodules. And Dr. Datnow confirmed this when he looked at the slide. Now, you said it's your opinion that she had a regenerative nodule, correct? Correct. And so remember, I had Dr. Robbins on the stand, and he said that the tissue they take out of when they do the biopsy is about 50,000. The liver's got 50,000 more tissue than that. So what you see on the tissue slide is 1/50,000th of what is actually in the liver. Here, let me show you his testimony real quick. So, doctor, if the slide is 1/50,000th of the whole liver, if you see a regenerative nodule in the slide, does that mean there's really 50,000 of them in the liver? The potential exists, yes. So Vanya has 50,000 regenerative nodules in her liver. That's the first big finding from this liver biopsy. This is the second big finding bridging fibrosis. And when you have regenerative nodules and bridging fibrosis, you have cirrhosis. That's permanent liver scarring, okay? Let me see Dr. Datnow, please. All right, in addition to regenerative nodules, does Vanya have bridging fibrosis?
Yes.
Good. And when you have regenerative nodules and bridging fibrosis, is that a permanent injury to the liver?
The regenerative nodule is a permanent change.
Okay. Now, this is something in addition to the fatty liver we've been talking about. This is permanent scarring on the liver called cirrhosis. There's no treatment for cirrhosis. It's not reversible. It's permanent. I'm going to show you, Dr. Let me see my next data now, please. So cirrhosis doesn't get better, not repaired by the liver over time. Is that your opinion to a reasonable degree of medicine?
Yes, once cirrhosis has occurred, it's irreversible.
Once the scarring goes to that state, it's irreversible. Doesn't go away. And there's no disagreement about this, okay? There's no disagreement about this because I asked Dr. Robin about it. Again, he was the defense pathologist. Here's what he said. If the slides show bridging fibrosis for Diaz and regenerative nodules for Diaz, she has cirrhosis, correct?
Well, not necessarily, but yes. Individuals who have bridging fibrosis and regenerative nodules have cirrhosis, but there are early stages where you might see regenerative nodules and what we would call bridging fibrosis.
And cirrhosis is the highest stage of liver scarring, correct?
Yes.
The highest stage. So in addition to fatty liver, she has cirrhosis, the highest stage of liver scarring. Okay, she got out of the hospital and then she went right back in. Same. Do we have the hospital? Oh, one more from Dr. Robin. Go ahead. Okay, and by that you mean there's some sort of way to lessen the impact. You can't cure the cirrhosis, right? No. Right. It's there. The permanent scarring is there. Yes. Forever. Yes. This is Real Water's expert saying that she has cirrhosis, permanent scarring, and it's there forever. And this is in addition to the fatty liver. Okay. So Vanya got out of the hospital and then she went right back in. Next, Shane. This is important. Okay, this is important. So remember, the defense has spent a lot of time saying, oh, these people, years later, they got normal ALTs and ASTs. Oh, so they're all good. They're all good. Their liver's fine. Again, an ALT and an AST means that the enzymes are elevated because something is attacking the liver at that point. When the attack ends, the ALTs and ASTs go down, all right? That's what ALT means. That does not mean that there is not permanent injury that caused by the attack. That means that the attack is not going on. And that's exactly what you would expect, because when people stop drinking real water, stop having rocket fuel go over their liver, it's not under attack. So the defense has used this as a misleading way of suggesting to you that if you have normal ALTs and ASTs, that proves the liver is good. That proves there's no problem. So that's why I asked the doctor, isn't it true that even if you have cirrhosis, the most advanced stage of liver scarring, level 4, isn't it true that you can have normal ALT and AST? Because the damage has been done. The cirrhosis is there. It's permanent. The attack is not continuing, which is what the ALT and AST measures. But so they can be normal and you can have cirrhosis. This is their doctor making this crucial admission. Go ahead, Shane. Okay, so let me ask a key question. Isn't it true
that people with cirrhosis can have absolutely normal ALT and AST. Is that not true? Yes or no?
That is true.
So when the defense gets up and says, oh, this person had normal ALT, AST 3 years later, they're trying to suggest to you that that means that there's no liver damage. That is not true. All that means is that at the time they took that ALT, AST test 3 years after these people were in the hospital, that their liver is not being attacked at that time. That doesn't mean they don't have cirrhosis, or in the case of most of the plaintiffs, fatty liver. All right? Okay, so I can't remember if this is the third or the fourth time that Vanya goes to the Henderson Hospital. Is this November 24th? This is, I think this is the third time, but same problems. So it's that cycle I told you about. You know, you go to the hospital, you're dehydrated, you drink hospital water, you get better. You go home, you drink the real water, you're sick again, you go back to the hospital. So this is her third trip. Next one, Shane. So Henderson Hospital, Mayo Clinic, 5 GI clinics, liver biopsy. So this is what Vanya went through. So let's compare her with Blaine. Okay, here's his back. Here's his sworn testimony. Again, this is the only valuation evidence in this entire case as to what an acute liver failure is worth. Everything else is going to be an argument from Real Water trying to get away from the sworn testimony of their vice president. Okay? So let's compare her to Blaine. She went to the ER and hospital 5 times. Blaine went 3 times. She had the liver biopsy. Blaine didn't. They were both told liver transplants was an option. Vanya was told, remember she had the 1 hour's worth of counseling. She's near death. Next. She had bridging fibrosis and degenerative nodules, which is cirrhosis, permanent liver injury. Blaine didn't have a biopsy. 50,000 regenerative nodules in her liver. And she didn't find out for 4 months that this was the poison that was causing her problem. So when you compare her to Blaine, I think she's far more damaged. Her compensation should be greater. So if the benchmark's 10 million, she should be above that, far above that, I would suggest. Let's go to the next plaintiff. Ginger Land Van Buren. Okay, again, she's the opera singer. She's hospitalized for 5 days at St. Rose from November 18th to November 23rd. And this was a medical miracle that she lived because she had the highest INR, and again, that means international normalized ratio. That's a measure of the blood's ability to clot. She had the highest INR that was ever recorded. Okay, next, Shane. So normal INR is 0.86 to 1.4. If you're above 4.9, it's life-threatening because you could bleed out, okay? She had 27. 27. Shane? I mean, it's hard to believe when you look at it, okay? 27 INR. And Dr. Hudson, and I think they asked Dr. Alcina this morning, no one's ever seen a 27 INR. Next, Shane.
Have you ever seen an INR that high?
Even with all the, I've done over 1,000 liver transplants now, well over 1,000. Never seen an INR that high.
So the problem when your INR is that high is that there's nothing that will clot the blood. So if you stick a needle into the patient, blood's going to spurt out and bleed out. And that's exactly what happened. Shane?
So my husband had to, it was basically move forward or it was death anyway. So he said it was tough for a moment to realize that I was in that spot, that it was either this or goodbye. So they put the PICC line in me, I guess, and I was having convulsions. So the blood had splattered all over the place when they did the PICC line, and was confusion, and he didn't realize that they were very concerned about the blood everywhere. I only know this because when I got out of the hospital, I had this pair of jeans at home, and it had my blood all over it, and he wouldn't let me wash them because he was afraid it was going to be the only thing left of me.
So because the blood didn't clot, when they stick the line in all over the place, all over the jeans, and you can see the anxiety in this video. I mean, her husband thought she was going to die. She thought she was going to die. No question about that. So let's compare, one more. She has permanent injury too. She suffered fatty liver as well. Okay, Shane?
This is urine. Land urine, I should say. Now, her medical records also indicate that she suffered fatty liver, is that correct? That is correct.
Okay, and these are in the medical records. No dispute about it. Real Water hasn't argued about it. So let's compare her to Blaine. Again, here's his baseline. Next, Shane. So Blaine's sick for weeks, or Ginger's sick for weeks before going to the hospital. Blaine's sick 2 days on that trip to Utah. Ginger had encephalopathy. Blaine's mental state, we don't know. Ginger had the highest INR ever recorded. Blaine didn't. Next. So they were both told that they may need liver transplants, both hospitalized by the same time. Ginger has permanent injury. Blaine doesn't. And so Ginger already told you that she's got these problems focusing and singing complex pieces, can't perform opera without using a reading sheet, which obviously you can't do if you're doing a live performance. So when you compare her to Blaine, we would suggest that this has got to be much, much higher. Okay? And I'm not suggesting what it is. I'm leaving that to your discretion, but it should be higher. All right, let's go to the next one. This is Carrie Mono. Remember, Nicole Chang and Carrie Mono have 2 children together. Okay, so Carrie went to the ER at St. Rose Martin on November 10th, 2020. He's admitted for 5 days from November 14th through November 18th. He's got ALTs, 1670 for the ALTs is high, 629 for the AST. But look at this ammonia level, 208, okay? Which is extremely high. That's 3 times normal, and that's why he was diagnosed with encephalopathy. He told you that he was so confused while he was in the hospital that he called his 16-year-old daughter and told her that he had died. He told his 16-year-old daughter that he had died and that she had to take care of the family. Shane?
Because I didn't know what was going on and everything kept coming in and out. And when I woke up, nobody was in the room and it was quiet. And apparently I found out later, I ended up calling my daughter, telling her, I'm sorry, I died, take care of everybody. And, what I'm told is I kind of traumatized her for life, but don't ever call me again if that happens.
What these families went through was unbelievable. In any event, after he's discharged from the first hospitalization, Carrie goes home, drinks more real water because he's dehydrated, and he's right back to the emergency room on December 23rd, 2020. Shane?
Well, actually, when we got released going home, our appetites were kind of off a little bit. We tried thinking we can sweat it out by exercising, working, and we just thought, drinking water to flush your body would make you feel better or whatnot, and ended up with the same symptoms all over again.
And why did he go back to the hospital again in December? because no one could tell him the answers, and there wasn't a recall from real water. I'm going to show you the October customer complaints, the testimony from Mr. Randolph, but Carrie had to go back to the hospital in December because there wasn't a recall from real water. And he illustrates this cycle. You drink the poison, you get sick, you go to the hospital, you get better, you drink the poison again, and you're right back in the hospital. A continuing nightmare. So the hospital found that Carrie had fatty liver. Likely fatty liver changes with fatty liver sparing near the porta hepatis. And Dr. Hudson told you that this was a permanent liver injury. Next, Shane.
Based on your review of his records, did he too suffer fatty liver as a result of consuming real water?
He did.
And is this your opinion in terms of Mr. Mono, that that's a permanent injury caused by consumption of real water?
Yes, sir.
So let's see Blaine's baseline one more time, Shane. Okay, and let's compare Carrie to Blaine. So they're sick about the same amount of time. I mean, Carrie had to go back to the hospital, true. Carrie had the high ammonia. He had, it says 8 years old on the slide, but the daughter was 16. And he told her he died, went to heaven. So the hospital documented, and Dr. Hudson says that you have the permanent injury of fatty liver. Blaine doesn't. Next, Shane. So Blaine was counseled for liver transplant, but neither one of them had a biopsy. And Carrie told you how he still has problems concentrating. So I think, you know, in fairness, Carrie's probably slightly higher than Blaine. I wouldn't say far, far higher. I would say slightly higher. So let's go to Glenn Morris. And let me put his medical situation in a little bit of context for you, okay? Dr. Cosnet and Dr. Robin, they both talked about this airman who was exposed to hydrazine for 1 minute, and he had liver function tests that were elevated. Okay, go ahead, Shane, pop it up. So we're talking about this 21-year-old who has the 1 minute exposure. Next, Shane. And these are the liver function tests for this guy who has 1 minute of exposure. 123, 145, 134, and 115. And then he goes back to normal. So he has moderately high ALT, AST. This is what Mr. Morris had. 8,310. Like I said before, he wins. He's got the highest AST of any plaintiff. And if you take a look at the INR, kind of hidden behind that one, but it's 6.91. That's twice the life-threatening limit. And they told Glenn that he might need a liver transplant. Glenn told you his reaction.
What was that like hearing you might need a liver transplant?
It was shocking. It was shocking, and that was pretty scary to hear.
So 2 tours of Iraq. And this is the news that shocks him. There's no question that he's got permanent injury. Here's what Dr. Hudson said.
So, Mr. Morris, did you review his medical records as well?
I did.
And based upon your review of his medical records, did you find that there was fatty liver, that he suffered fatty liver as well?
Yes, sir.
And based upon your review of his medical records, did he suffer a permanent injury?
Yes, sir.
Okay, and Glenn told you that he has complications to this day. Shoot, Shane.
As you sit here today, do you still feel like you have any issues associated with real water?
Yeah, like I try to see if a whole week can pass if I don't have no stomach complications. Sometimes a week will pass, and not 2 weeks, where I'm going to be bloated and lose appetite, and really just stomach indigestion. Yeah, pretty much.
And we talked about his psychological injury, okay? And again, he had PTSD from Iraq, but he had learned how to deal with it. Now he's right back. Here's what he told you.
Somebody try to ignore it.
Tries to cope, tries to ignore it. So for some reason that I don't understand, on the cross-examination, the defense attorneys went after Mr. Morris a little bit. Despite the fact that he had PTSD from the Iraqi war, despite the fact that he had suicidal tendencies, he admitted it, okay? And despite the fact that he has PTSD, they went after him, okay? And this is the final ugly exchange that they had with a person that they knew had contemplated suicide. Shane?
Yeah, you know what? This is not easy to talk about, man. Enough to be in this courtroom. If I knew I had to, or to stay away from your water, if I knew I had to deal with this, man, this is enough.
This man needs help. He doesn't need verbal attacks that are needless. He needs help. So let's take a look at the comparison between him and Blaine Jones. Here's Blaine's baseline again. Here's Glenn versus Blaine. So Glenn went to the VA, ER, 5 doctors visit, hospitalized VA, UMC, 5 days. Blaine had no doctor's visit. Glenn has the highest AT of anyone in the case. We don't know about Blaine's. Both had acute liver failure. Both total liver transplants an option. Glenn has continuing gastro issues, PTSD, no evidence. Blaine does. Glenn has 6.91 INR. Blaine's unknown. Blaine was probably hospitalized a couple more days. And we know that Glenn has permanent injury. Blaine doesn't. So with that in mind, we would suggest that Glenn should be much higher than Blaine. And again, I think the thing I'm really focusing on is this 8,000 AST. Severe injury. Okay, next. This is Sherry Nally. Again, she's Ginger's mom. Remember, she came down from Oregon when Ginger got sick to take care of her. So she's hospitalized. She comes down, she starts drinking the real water at Ginger's house, and she gets sick. So she's hospitalized on November 16th, 2020 at St. Rose for 3 days. She has ALT 258, AST of 412, INR of 133, and they diagnosed her with acute liver failure and encephalopathy. Okay, she owned the dog. The dog died. His name was Buckley. And remember, we're not seeking compensation for the value of the dog. Okay, that's not a damages item in this case. But her dog did die. She has permanent liver injury. Let me show you the slide from St. Rose. Mild to moderate diffuse fatty infiltration of the liver. This is what they found at the hospital. Next, Dr. Hudson.
And is it your opinion, Dr. Hudson, that Ms. Nally has now suffered a form of permanent liver injury based on her consumption of real water? Yes, sir.
You know, and the real water expert comes on here and he says, oh, her prognosis is good. Doesn't say anything about the fact that she has fatty liver. Doesn't dispute that. Just says, oh, I think her prognosis is good, whatever that means. So she has continuing problems. This is a record from, I think it's 2022. I'm not sure. I can't see the date up there. Yeah, 2022. So she's having continued problems, can't multitask. You know, this is the brain fog that we've heard so much about. She wants to stay on top. And then here's what she told you.
This record notes that you can no longer multitask like you used to.
Yeah.
Did you have these memory or multitasking problems prior
to you getting sick from real water in November 2020?
Not that I can recall.
Did they start after your liver damage from real water?
Yes.
Okay, and then this is April 2022, so this long after your November 2020 hospitalization, you're still seeking treatment for these effects, correct?
Yes.
Okay, let's compare her to Blaine, quick. There's standard. Okay, both acute liver failure. She has permanent injury. Blaine doesn't. She has brain fog. Blaine doesn't. She's older though. Okay, next Shane. No, back please. And we think that it probably should be less than Blaine's standard. We'll leave it to you how much less, but we think it should probably be a little less.
Your Honor, number 4 should be stricken on this slide. We've already had a.
Judge, I specifically explained this. I specifically explained we're not seeking compensatory
Then
damage.
it shouldn't be up on the board, should it? It's appealing to sympathy, Your Honor. Has to be removed.
Judge, can we approach rather than hear Mr. Johnson's impromptu?
Thank you. Okay, ladies and gentlemen, we'll take a restroom break right now. Remember, you're admonished not to converse amongst yourselves or anyone else in any subject matter connected with this trial, or to read, watch, or listen to new reports or comment on the trial. Finding persons connected with this case, or by any medium of information, including documentations, newspaper, television, radio, social media. Remember the prohibition. Last but not least, do not form or express any opinion until the cause is finally submitted to you for deliberations. And let's just take a break.
All rights to the jury. Jury clear?
All right.
Yeah, Judge, at the bench, I asked that Mr. Johnson be admonished because he has interrupted my closing argument 3 times now. This is the 5th closing argument I've done in this series of cases. I have never been interrupted even once. He's now done it 3 times. It's a tactical effort by the defense to interrupt my flow. And that last objection was extremely frivolous because there's been testimony for both Nally and Van Buren that this dog Buckley died. Number 1. That's in the record, okay? Number 2, there's an FDA report that says animals died. That is in the record. That's a stipulated exhibit. Number 3, I went out of my way and told the jury that we were not seeking compensation for this dog before this incident. I made his argument for him. I went out of my way. And so for him to jump up there and object over and over and over again, this is just a calculated effort by the defense to interrupt with the flow of an argument, and he should be admonished and told that unless he's got a serious objection of an impropriety, he should sit down and let me finish my argument.
Your Honor, I don't care how many times Mr. Kemp's given an opening and no objection. I don't think anybody on the planet does other than him. Number 2 is that's not a basis for whatever this screed is about. It is very clear that he is appealing to the emotion and sympathy tendencies of the jury, which is an inappropriate argument. Now talk about holding it in. He's violated the golden rule argument throughout this scripted presentation that apparently he's given 5 times and no one's objected to it before. He's repeatedly said, you have to do this, you have to go to the hospital, you have to do all of that. I've let it go, but it got horrifically wrong when he got up there knowing that non-economic damages such as damages for past or future pain and suffering may not be awarded in this action for the injury of a death of a pet. When they got these folks up there, Your Honor, and talked about the pets, I didn't object because they can recover vet bills. They never introduced them, Your Honor. That's why that was relevant. I chose, let's not make a big deal out of the pets until we get to jury instructions, because if they haven't brought up the vet bills, which are capped at $5,000, it's not going to go to this jury. They didn't do us any favors at all. Nevertheless, we presented this jury instruction. They agreed to it, and I'll be darned if he didn't bring up the pet thing again, which he knows he's not supposed to do. He knows he's doing it to get sympathy from the jury. Poor Miss Natalie's puppy died, and then put it up on the board. I have an absolute right to object. I don't have to run up to the bench every time with an objection. It's a clear violation of the order that the court issued, a clear violation of the jury instructions. He's asking the jury to forget the law, to nullify the law, to somehow give them additional sympathy because puppy died. That is inappropriate, and that should be the admonishment. Thank you.
Yeah, Judge, they lost that motion in limine. They filed a motion in limine to preclude us from bringing up such pets, and they lost that motion in limine. That's why the exhibit's admitted. The FDA is a stipulated exhibit. Now they're trying to twist this jury instruction that you don't get compensation for pets into something completely different. And as I said 3 times already, I told the jury before I got into this, I told them that we were not seeking compensation for the dogs. So for him to suggest that this is inappropriate is just wrong, and he's just running away at the mouth because he wants to interrupt my flow. 3 times he's gotten up there, which is outrageous. That is outrageous behavior in this jurisdiction. He knows there's not a darn thing I've said that's inappropriate. He's got the transcript from the previous trials where I gave the similar argument. Not one word, not one objection in the similar trials, Your Honor.
I would just add that counsel is wrong about the objections. He can make an objection where he's just stating an objection like relevance, hearsay, but when he makes a speaking objection, he cannot do that from counsel table. That are our rules. No speaking objections. He has to request to approach, and I would request that the court instruct him to do so from now on.
Yeah, Judge, and this isn't the first time. He stood in front of the jury and yelled and screamed that Dr. Sands was engaged in speculation and said, I want to strike all his testimony. That was so inappropriate, and this is the same type of behavior, Your Honor. He could have said, let's approach the bench and made his objection. But instead, he stood up and grandstanded in front of the jury and acted like I did something totally inappropriate, which I didn't.
He put it up on the board and left it there, Your Honor. Not going to do me any good to run up to he's leaving it up there. It should have never been put up there. All I ask is to take it down. Thank you.
Anything else anybody want to comment? Because I think it's important to point out, number one, what the status of the evidence is in this case. Because ultimately, I made a decision, not just in this case, but in the very first case regarding the extent of the evidence that might be admissible in a products liability case pursuant to the Restatement of Torts 402A. And it's my recollection that I prepared a 6-point analysis in a minute order in the first trial. And I've been relying upon that analysis throughout the entire case. And this is why it's important. It deals specifically with issues regarding general causation in this case. And I listened to the argument made by Mr. Kemp in this respect. Number one, he was really clear in that there were going to be no damages sought for the unfortunate loss of the pet of this plaintiff. Nonetheless, I don't think there's been any orders entered prohibiting him from pointing out the fact that her dog died, ultimately, right? And I think the order was pretty clear and specific as to what specific evidence would be admitted. And it's my recollection, for example, wasn't it the Krause case specifically? The latter case, right? And in that case, remember, it was pretty clear that the plaintiff didn't even recollect hitting the lever as they went down the ladder. And nonetheless, what did the Supreme Court say? That comes in, right? And so I'm looking at it through this lens. There was no damage claim. There was no in limine motion that I granted that would prohibit pointing out the fact that her dog unfortunately passed away because of the fact that the dog was drinking real water. And that's really the status of the case. And so what I'm going to do at this point, we're just going to move on. The objections noted, there's no claim for damages as far as the unfortunate loss of her pet. And for some people, that's very important. I will say that. But nonetheless, the facts are the facts. And I entered no order prohibiting anyone from mentioning that fact. Right? Did I?
No, Your Honor.
No, I didn't. And so my point is this. He didn't make a claim for damages for the dog. Right?
I respect your ruling. My point is, and for the record, this is an argument that is solely to get sympathy from the jury, which is improper. And we know that because they can't recover for it. That's kind of like saying, hey, I'm not asking for money for it, but these are terrible, terrible people. It's an inappropriate argument couched in that language.
I don't even know if it was made in that regard. It was just pointing, I mean, the record will speak for itself, but it's my recollection. He pointed out, unfortunately, she lost her dog. And
it's irrelevant, Your Honor.
Well,
and just so you know,
so
Your Honor,
if it's irrelevant, then I mean, this record is full of testimony regarding injuries to pets.
right, but this is their list of, here's what she suffered versus Blaine Jones. This tired comparison that I guess we're going to go through 15 times. She lost her dog. I guess Blaine has a cat that's living. That's what it was brought up for, to engender.
I'm going to be candid with you. I didn't see it that way at all.
He didn't say that.
I mean, I just.
And by the way, it's contained within an exhibit that's been admitted in this case, which the defense never objected to.
Again, we have a jury instruction. They didn't bring up the fact that they were seeking vet bills. That would be the only reason why it was relevant. And because of that, all of this line of presentation to the jury is inappropriate. But the court made its ruling.
But I mean, ultimately, here's my point, though. That evidence, if it was irrelevant, it would not have been admitted in this trial. And ultimately, the Supreme Court's going to have to make a decision regarding that. And you have to understand and remember the unique nature of this case, because from an FDA perspective, some of the original testing was done on animals. And they found that the hydrazine was so toxic, they couldn't do any further testing.
And what was also clear on this, on the record, is the terrible, irrelevant objections I previously made. I'm fairly certain one was actually sustained, Your Honor. So,
I mean,
if
I don't
you
know
want
what,
me to come up to the bench every single time
No, I
on
don't,
objection,
but-
I will, but I didn't know that was the rule.
No, I didn't. Did I say that was a rule?
No.
The counsel did.
But
and-
I didn't say that.
Okay,
I didn't
thank
say I agreed with them. I'm just trying to move on. Right? I'm just
I
trying.
would request that speaking objection be made at the bench, not at the counsel's table.
Yeah, I understand.
I would again ask that this constant interruption, tactical maneuver by the defense to interrupt my flow, stop.
Your Honor, we've been going an hour and a half, constant interruptions.
3 times.
Now, that's outrageous. That's constant. It's once every 30 minutes. My objections are plain and to the point, Your Honor. It's pretty hard to lose the flow.
It's respected, but my point is this. I just didn't interpret it in the same manner, form, and or fashion. Just as important too. I don't think I granted a motion in limine excluding because of the general causation issue that we talked about. And that was well developed, and that's going to be an appellate issue. I understand, I would anticipate our Nevada Supreme Court case, our Nevada Supreme Court's potentially going to grapple with that issue. But you know what? This is a mass tort case. You know, we understand issues regarding general causation. All we can look to as far as how the potential toxicity of hydrazine is a few animal studies that were done quite some time ago, number one. And I guess secondly, the unfortunate event involving the airmen. That's all we have. And anything beyond that, we don't have, because and I pointed this out at some time ago, from an ethical perspective, how can you test the impact of hydrazine on people? You can't do that. You know, so there's not going to be any studies you look for. This isn't like potentially determining what's the impact of giving someone high dosages of vitamin C. It's not the same thing, right? It's not the same thing at all. This is hydrazine. And my point is this, and instead of pulling out my yellow pen and highlighting something, I'm just going to let it move on because I don't want to put that much emphasis on it either way. I'm not going to say, look, sir, you can't object. I'm not going to say that. I'm not going to do that. I'm not going to, but as far as pulling it down, we're just going to move on.
All right.
And continue with closing arguments. And Mr. Kemp, you know we're not in a rush, but how much more time do you expect?
I'm ready, Your Honor. Well,
No. As far as how much time do you have remaining? Half hour?
I think I got about an hour, Your Honor. I think this interruption kept me from finishing today.
Okay. No, I understand. We'll finish it when we can.
Right.
Thank you.
But the jury has taken a quick recess. I think my staff needs to take one too, right?
Yes.
Yes. We'll step down.
All right.
Please be seated, thank you.
Okay, we're back on the record. And you ready, Mr. Kemp?
Yes, Your Honor.
Oh, I'm sorry, Your Honor. Teddy Park on behalf of plaintiff.
Robert Eglin on behalf of plaintiff, Your Honor.
Maggie Federico on behalf of plaintiff. Rand Switzer on behalf of plaintiff.
Eric Copperman for plaintiff.
Brad Johnson, Tyler Watson, Michael Esposito, and Eric Freeman on behalf of the defendants, Your Honor.
All right. And how much more time do you think you have for the afternoon, Mr. Kemp?
Your Honor, I think I can get to the punitive damages section in
That's fine. I'm
30
not
minutes.
rushing.
Just stop before I start that.
Okay. All right.
Dead in the middle of your party. Yeah. Yeah. Yeah, felt bad. Get back on that horse.
Yeah, tomorrow I have 2 or 3 contestants on it. I know it's 10:30.
All right.
I see him back.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
We do, Your Honor.
And so, ladies and gentlemen, we're going to continue with closing arguments by Mr. Kemp. It's my understanding he'll probably go about 20 minutes or so, give or take. Then we'll break for today, and then we'll continue tomorrow at 10:30.
Okay, ladies and gentlemen, we left off with Abraham. Here's a picture of him. He told you he started feeling sick at the Halloween party in October 2020. So he's hospitalized at Sunrise 5 days, November 6th to November 9th. Pediatric intensive care because he was 15 at the time. So he had ASTs, 900s, ALTs, 400s, INR 2.9. They diagnosed acute liver failure. And I point out that the medical records say acute liver failure specifically. And I point this out because I don't know what Dr. Lim was trying to say, but the records say acute liver failure. He was trying to downgrade that to some sort of serious liver injury, but it says acute liver failure right on the records, specifically like everybody else's. his ammonia, okay, and Dr. Hudson agreed that Abraham had acute liver failure. Here's Dr. Hudson.
And all of the plaintiffs that you reviewed had acute liver injuries.
They did.
And Abraham had ammonia of 56. They told him he might have to go to a transplant center. And there's a little more concern for a younger person, like the 5 children that they flew to Salt Lake, like Abraham, because of his age. So they said he may have to go to a liver transplant center. And they told him he may need a transplant. And he talked to you about this, how he felt when they told him this. Go ahead.
They said that my liver was very bad, and it looked like I had took an entire bottle of ibuprofen, as if I was depressed, trying to kill myself or anything. They said it was very bad, and that if it doesn't progress, if it doesn't get any better, that they will fly me out for a liver transplant.
Okay. And they told Abraham that he might die. Next, Shane. Failure to provide this level of care may result in further organ system dysfunction or death. And by God's grace, Abraham survived, did not have to have a liver transplant. Didn't have to be flown to LA. Okay. But he has permanent liver injury, again, fatty liver. Next, Shane.
Did Abraham also suffer, based upon his medical records, a fatty liver because of his consumption of real oil?
Yes, sir.
And do you also believe that Mr. Oliveira has suffered a permanent liver injury because of his consumption of real oil?
I do.
Okay, and the judge read you the life expectancy table for Abraham. Shane, can I have that popped up? So he's going to live another 59.8 years, let's just say 60. And the reason we bring that to your attention is 60 years he has to suffer with this permanent liver injury, specifically the fatty liver. 60 years. Okay, so let's compare him to Blaine Jones. Next, Shane. Acute liver failure, both told about the transplant. Abraham also told maybe he's going to die. Permanent liver injury, Blaine doesn't. Abraham's decades younger than Blaine, and he's going to be suffering for 60 years. So I think using Blaine's $10 million number as a standard, Abraham should be higher. How much higher, I leave it to your discretion. Next plaintiff, Carolyn Strong. Okay, Carolyn and her daughter, Kathleen Gassius, they were the tourists from California that came to hike at Red Rock. So it took real water with them on the hike. Carolyn was hospitalized for 3 days from October 21st, 2020 to October 24th, 2020 in Las Vegas. And they did a CAT scan on her liver. No surprise, they find fatty liver. Then she went back to her house in California, and she's hospitalized again in California, and she told you a little bit about it. Next, Shane.
Yes, I had my blood drawn every 4 hours, and all through the night, waking up in the middle of the night, I had an IV in, and eventually they were sticking me everywhere, and my veins started to scar up, so they had to do blood draws out of my feet. And that was for a week total that I was in the hospital having all that done.
Okay, and that's the Naval Hospital in San Diego. So while she's at the Naval Hospital, they do a liver biopsy on her. Shane? So this is the trichrome stain. And again, remember they put 3 stains on these liver biopsies to look for scarring. Blue is bad, blue is scarring. So here we have her blue. Not as bad as Vanya's, okay, but we have scarring here, okay. And the liver showed bridging fibrosis in addition to the fatty liver. Here's what Dr. Datnow said.
Where's the bridging? There's another one over there.
Where's the bridging?
You can see the fibrous tissue going zigzagging around from one to another.
Okay, and this is bridging fibrosis. It's not a regenerative nodule like Vanya has.
Correct.
Okay, and so Vanya has both bridging and regenerative nodules, 50,000 of them, but Carolyn only has the bridging it's serious injury. She has bridging fibrosis, and you can see the bridging yourself, the blue between those two ports there. The ports are the circles there that Dr. Datnow just showed you.
These are apoptotic cells. You see they've lost their nucleus. So the nucleus is this blue dot that's in the cell, and when they lose it like this, that's an apoptotic cell, it's a dying cell. So in the progression, it goes from fatty change, ballooning degeneration, apoptosis, and it's dead.
Okay. Any question in your mind that the strong slide shows serious liver injury?
No question.
Okay, and bridging fibrosis is a serious liver injury. Even the defense pathologist, again, this is Dr. Robin, also from San Diego, he agreed. I showed him the findings, the liver biopsy of the airman, the 21-year-old who was exposed for 1 minute. I showed him those, and he agreed that Carolyn has the same findings. Let's see, Dr. Robin.
The biopsy report says portal inflammatory infiltrate, correct?
Yes.
And you agree with that? You saw that?
Yes.
And cholestasis, you saw that?
Yes.
Okay. And again, those two things that Porter and the 21-year-old, he had both of those two, right?
Yes. 21 years old, 1 minute of exposure, he died of the same things that Carolyn has. This is the defense. The defense is admitting this. Okay. And he also conceded that the liver function tests for both Carolyn and Vanya were worse than this airman. Next, Shane.
Okay, so ALT 123, 145, 134, 115, and then 34, it almost goes back to normal on day 21. So he had elevated ALTs, right?
Yes.
But Ms. Diaz she had elevated ALTs of 2,000, right?
Yes.
And let's take a look at this poor airman's ASTs. 321, 378, 204, 152, and 19. Correct?
Yes.
All above normal?
Yes.
But Ms. Diaz had ASTs in the thousands, correct?
Yes.
So, would you agree with me that Ms. Diaz had a more serious injury than this airman?
It appears that way, yes. I think she had a more severe acute injury. Yes.
Okay, fair. And the same is true of Carolyn Strong. She had higher ALTs and ASTs than this too, right?
Yes.
This is the defense pathologist. This is the one that Real Water presented to you, and he is telling you that the injuries of both Carolyn and Vanya were worse than this 21-year-old airman that died. So Dr. Datnow rated the fibrosis level, and again, Shane?
Okay, and did you find periportal and pericellular fibrosis here?
Yes, you can see here's a liver cell, and it's surrounded by blue fibrous tissue that's pericellular. This is the portal area, so that's periportal.
Okay. And you graded this what?
1 to 2.
Okay, so this is not just fatty liver like everybody else has. This also is portal fibrosis and periportal fibrosis, stage 1 to 2. So let's compare this to Blaine. Again, here's his sworn testimony. And here's the comparison. They're both hospitalized about the same time. Carolyn had higher AST/ALTs than the F-16 pilot. We don't have Blaine's, but I assume his is also higher. Carolyn had a liver biopsy. Blaine didn't. Carolyn had the same findings on the past slide that we just went about that the airman did. Bridging fibrosis, periportal fibrosis, and pericellular fibrosis. We don't know what Blaine had. They told Blaine maybe we're going to have to do a transplant. They didn't tell Carolyn that. And then the Summerlin Hospital found Carolyn had fatty liver, and Dr. Hudson says that it was caused by the hydrazine. And so back Shane. So what we would submit is she should be a little more, maybe a little bit more quite a bit more actually than Blaine Jones. So the very last plaintiff we're going to go through is, this is Carolyn's daughter. This is Kathleen Gassius, and she had a moderate physical injury, okay? We are not claiming that she had fatty liver. We are not claiming that she had permanent liver injury. We're claiming that she had a moderate injury, and she had some other injuries that I'm going to talk about in a minute, okay? So remember, this is the one I told you during opening statement that we were going to seek the lowest amount for. All right, I told you that during opening. Go ahead, Shane. Let Kathleen describe her injuries.
Yes, on the last day, I had really bad nausea. I started throwing up, gastrointestinal distress, and then I lost my appetite for a long time. I drastically dropped weight. I think I dropped like 10 pounds in 2 months. Just didn't have appetite, and yeah, that was starting on the last day that we were here.
Okay, and she also had mental trauma that's similar to the other plaintiffs. Go ahead, Shane.
It's been the most traumatic experience of my life. I never had anxiety before this, and I've had really, really debilitating anxiety. I was diagnosed with PTSD. I had to go to therapy 2 times a week to just kind of like get to the point where I could like hear an ambulance drive by and not feel panicked.
Now, Carolyn had a unique mental injury because it was a unique set of circumstances. Her mother is in the hospital in San Diego. Remember, she was there December 7th getting the liver biopsy. So her mother is out of the picture, and at this exact same time, her grandfather's dying. Carolyn's father, her grandfather. And so this poor woman had to take care of both a critically ill mother and a dying grandfather. Next one, Shane.
We had to bring a caregiver for my father, but just scary not to even be there for my family, and like having my kids worry about me. And as a parent, you want to be the one taking care of your kids, not them taking care of you. Worried.
So it interfered with those personal relationships with your dad?
Absolutely. And then by the time I was feeling better and could come to their house to see them, he passed away a month later. So I missed a lot of that time with him and my grandkids.
Okay, so Carolyn, again, moderate injury, a lot of mental anguish. And again, we think it's not fair to compare this to Blaine Jones because Carolyn didn't have acute liver failure like Blaine Jones did. So I'm not even going to try to get this up there. But we think she's entitled to reasonable compensation, and we leave it up to you. Do I got another one, Shane? Okay, go ahead.
And when she first went to the hospital, my first thought was like, I haven't had babies yet, I want her to be a grandma to my babies, and just was like grasping for that time with her. And not being able to be in the room and not being able to know that she was there, and it was life-changing for me and my siblings and her husband, and it's been very difficult. There's been a big sense of betrayal, that this happened to our family.
Okay. Now, let's go to the second part of the verdict form. The second part of the verdict form are future damages. Okay? And future physical and mental pain, suffering, and anguish. So those are a little more difficult than past damages because there's no study anywhere where rocket fuel has been poured on livers of people. Okay? No study anywhere. And I think the biggest future damage in this case, since there is no study, is the fear and anxiety of unknown possible injuries from having the rocket fuel poured on their liver. And we're not asking for compensation for these possible injuries. We're not saying you should give us the cost of liver transplant operations. We're not asking for that, okay? But there is the fear and anxiety of the unknown. And let's talk about the fear of the unknown. This is a quote from a science fiction writer in the 20s. And he was named H.P. Lovecraft. Okay, he's a science fiction writer. Stephen King, who you may have heard of, he's a current science fiction writer. He's a big fan. So Lovecraft wrote this: "The oldest and strongest emotion of mankind is fear. And the oldest and strongest kind of fear is fear of the unknown." The strongest emotion is fear. The strongest kind of fear is fear of the unknown. All 13 plaintiffs in this case have fear of the unknown. And let me explain to you why they have fear and why it is a concrete fear. Let's start with the animal studies. I told you, we can't do studies pouring rocket fuel on human beings, but they've done it on animals, and this is what they showed according to Dr. Kosnet.
So then I looked at studies that had looked at not just animals getting a single high dose, but getting lower doses over a period of time. And one of the studies that was published was done in Germany in 1988. And they actually, in this, they gave male and female rats different doses of hydrazine in drinking water. Okay? They gave it to them in drinking water, and they gave it to them over the course of greater than a year. And then when the animals died, they did autopsies on the animals. And they had started this study because they thought they wanted to look at whether hydrazine caused cancer. It turned out it didn't cause cancer, but one of the things that they found was that it caused an increase in the prevalence of what's called bile duct hyperplasia, or a thickening or abnormality of the bile ducts. And those are an important component of the liver. So this was an example of how chronic exposure to hydrazine at lower dose that didn't kill the animals right away caused them to develop abnormalities in the liver.
So we know 4 things. Okay? 1, when they gave this rocket fuel to rats in low doses, it caused them to die because of liver problems. 2, we haven't been able to do studies on humans because that would be unethical, but we do have the 2 case reports of people dying from hydrazine exposure, one for 1 minute. And Dr. Hudson says that the plaintiffs have permanent injury. So all the plaintiffs have a fear of the unknown. And let me give you an example, okay? Shane, can we have Vanya?
And for the next 2.5 months, I couldn't sleep because I was afraid that if I fall asleep, I'm gonna die, not wake up. I have health anxiety. I actually probably have a lot of health anxiety because when something arises nowadays and I feel something, I'm constantly like thinking, okay, what is going on? To know that I drank rocket fuel gives me tons of anxiety because I have no idea what long-term consequences that would have on my lifespan.
And remember Blaine Jones told us hell and back? You don't go to hell and back without some fear of what's going to happen to you in the future. And it's worse for the plaintiffs that have the pathology slides showing, like Vanya's got, the regenerative nodules, the bridging fibrosis. No one knows what problems they're going to have, but we know the rats died from low exposures to hydrazine. And so for sure, they all have a significant fear of the unknowns. Okay, now let me shift gears a little bit here. And let me talk to you about the 3 primary defenses that we've seen in this case. So here they are. 1, they engaged in something called the illusory truth, psychological manipulation. I'm going to explain that in a second. 2, and we've talked about this a little bit, They kept saying, oh, look at all these normal ALTs, AST, that proves that there's no permanent injury. Doesn't prove that. And then 3, this magic liver theory. You know, you can pour rocket fuel on your liver and it heals itself. Okay, those are the 3 big defenses. When you boil down what's been going on for the last 2 weeks, that's what's been going on. So let's start with the second defense. Or excuse me, we can do the first defense, Shane? Okay, let's do the first defense. Okay, this is a direct quote from Mr. Johnson during the voir dire. This is not me talking. This is what Mr. Johnson told you. He asked you, have you ever heard a theory known in psychology as the illusory truth effect, also known as the illusion of truth? It describes when we hear the same false information repeated again and again, and we often come to believe it's true, and it's reinforced and other people believe it's true. Okay, next one, Shane. This is also what he said about the same thing. So your cognizant of that theory is that things said over and over that may not be true, you adopt it because everyone else is adopting it. So why would a defense attorney ask you if you knew about this psychological trick? And what term have you heard from the defense over and over and over again in this case? What term have you used that they're trying to play this psychological trick that Mr. Johnson admitted to? He admitted, these are his words. He said that he wanted you to know if you knew about this trick because they knew they were going to play this trick. So what word, what terminology have you heard over and over again? Great news! Great news! This is great news! Good news! Great news! Over and over again, we counted the transcript. They used that terminology at least 60 to 70 times. And don't take my word for it. Shane?
Great news. The news is great. The absolute great news. Look at the good news. Fantastic news. And that's good news. The great news. The great news. That's good news. Good news.
It's great news. It's great news. Good news. Great news. You think that's great news?
That was good news. Great. Okay, great.
Good news.
Good news. It's great news, basically.
So this was a deliberate defense strategy to engage in psychological manipulation. Okay? They didn't want you to look at the evidence, all this fatty liver evidence I've been talking about. They wanted to use this little psychological game. So a plaintiff gets out of the hospital after a week of intensive care. Great news! Plaintiff escapes having to have a liver transplant. Oh, great news! Plaintiff has liver failure because there's not a timely recall. Oh, great news! This is all great news. And then a plaintiff finally gets out of the hospital after days or weeks of intensive care. Oh, great news! And then a plaintiff, after suffering from weeks or months, we see a little bit of improvement. That's great news, according to Mr. Johnson. Well, ladies and gentlemen, there's no great news in this case. These people have permanent liver injury. That's not great news. And the plaintiffs told you that this was not great news. Next, Shane.
Is that great news?
See, great news.
Great.
There's nothing about my experiences with real water and the subsequent treatment and care that I would classify as great news, sir.
Yeah, JJ's a little older than some of us. You know, he's on top of it. He saw this psychological trick coming a mile away. But this case is not about a psychological mind game, okay? That's not what this case is about. This is a case about people that were severely and permanently injured because they drink rocket fuel in a bottled water. That's what this case about. And the court has instructed you not to consider arguments like this, great news, great news, great news. Here's the jury instruction. Well, I hope it is, Shane. 8. Okay, their statements, their arguments, their opinions that something is great, that's not evidence in this case. Okay, that is not evidence, right? So let's go to the second defense, and we've talked about already, oh, everyone's got normal ALT and AST. Well, that doesn't prove that there's no permanent liver injury. Like I said, that proves that the liver's not currently being attacked, but that doesn't prove that the big attack didn't cause permanent injury. And why do we know this is true? Because this is their pathologist. Go ahead, Shane.
Okay, so let me ask a key question. Is it true that people with cirrhosis can have absolutely normal ALT and AST? Is that not true? Yes or no?
That is true.
Okay, so you can have cirrhosis, the worst scarring, and you'll have a normal ALT and AST. So all of these references to ALT and AST 2 or 3 years later, it doesn't disprove that there's not permanent injury in this case. And let me get to my last one, okay? This is what I call the magic liver theory. The liver is a wonderful instrument. It heals it. That's supposed to be a wand with pixie dust, you know. It heals itself after someone drinks hydrazine. Okay, that's the theory that they've been telling you. All right. First, the scientific papers prove that people die when they drink hydrazine. Not that hydrazine fixes itself. And this is an admission by their defense pathologist.
And would I be correct that actually there is scientific literature that suggests that when people are exposed to hydrazine, even for 1 day or a small amount, not only does the liver not repair itself, but those people die? Would I be correct?
There are a couple case reports of that, yes.
So the scientific literature, the clinical studies, all the articles, says that there is no magic liver when there's hydrazine, and this is the defense expert admitting that. Okay, second, there is no scientific literature. There's no paper, there's no study, there's nothing out there that supports this magic liver theory with regards to hydrazine. And I've got 3 different clips from Dr. Robbins where he tells you exactly that. Go ahead, Shane.
And I'm going to call this the magic liver theory, okay? You pour rocket fuel on someone's liver, magically the liver can regenerate itself. So when I'm talking about the magic liver theory, that's what I'm referring to. Okay, doctor, would I be correct that there is no scientific literature studying people that have consumed hydrazine that suggests that the liver can repair itself? None.
Yes.
So there's no scientific support for this claim that's been asserted that, oh, the liver's magic, all these people are getting better or they're going to be better. No literature. There's no evidence of that. And he says it again, Shane.
So doctor, the question, and I'll let you explain anything you want. The question is, there are no articles on human beings where we pour hydrazine on their liver that shows that the liver magically repairs itself, correct?
No, not on hydrazine, that is correct.
No magic liver science. And this is the last one. Shane?
So let's take the first part of your statement. The liver has the capacity to cure itself. Again, no scientific studies whatsoever support that proposition in regards to hydrazine testing, right?
That's correct.
This is important. The whole defense magic liver theory is founded upon arguments from the attorneys. No scientific literature. And I think on that note, ladies and gentlemen, let's stop for today. And I've got a couple more minutes that I'm going to try to do tomorrow. And then I'm going to turn it over to Mr. Parker. Okay, thank you very much for your attention, and I'll be back with you just for a couple more minutes tomorrow. Thank you.
All right, ladies and gentlemen, we're going to break for the evening, and we'll reconvene tomorrow at 10:30. And the reason why we're doing 10:30 is I do have matters on calendar. Try to get here, because we're going to try to start as soon as we can, close to 10:30, and continue with arguments. You understand? Just as important to remember, you're admonished not to converse amongst yourselves or with anyone else on any subject matter connected with this trial, or to read, watch, or listen to any report or commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Remember the prohibition. Last but not least, do not form or express any opinion on any subject matter connected with the trial until the cause is finally submitted to you. And so tomorrow at 10:30, I'm going to try to be ready to go. If we're running a little late, it's because I have other cases. Just remember that. But we're ready. We're going to try to be ready to go and continue on. Okay, sir.
All rise to the door to the jury.
Thank you, sir. All right, welcome. Let me go off the record. Thank you.
So I'm putting you a list of all of the admitted exhibits just before we turn the case over to the jury.